Calling our next case this morning, Stokes versus Swofford. This is a 15-minute mini oral argument on the application. Welcome, counsel. Welcome back. You may reserve some of your time if we do not use it up, and we ask that you do your best to keep track of your own time. You have 2 minutes of a free fire zone. Please begin when you're ready.
May it please the court, Michael Cook on behalf of the defendants, appellants, Dr. Michael Swofford and Southfield Radiology Associates. The point that I think this court should focus on and try to clarify in this case is this line from Woodard. It held that the relevant specialty for medical malpractice cases is, quote, the specialty engaged in by the defendant physician during the course of the alleged malpractice. That's a little equivocal. That could be the specialty engaged in, meaning the specific service at issue, or it could be the specialty engaged in terms of the defendant's overall practice. And the rule I think this court should set out and adopt and make clear is that the defendant's overall practice is what establishes the universe of potential specialties. And I think you can find support, and that's rooted in the 2 statutes that I see are at issue in this case. MCL 600-2912A, which speaks in terms of what the plaintiff needs to establish in terms of the standard of care, which is the defendant, if a specialist, failed to provide the recognized standard of practice or care within that specialty. So that's contemplating what the defendant's practice is, what specialties they actually possess. Same with MCL 600-2169, which gets a lot of focus in the briefing in this case, refers to the defendant if the defendant is a specialist. Again, contemplating what practice the defendant actually has. So in this case, I think this Court of Appeals error was it skipped over that first threshold point, which was defining and determining the specialties the defendant actually practices. And specifically, whether Dr. Swofford, in this case, was a neuroradiologist at the time of the alleged malpractice. That factual point is actually the only point of disagreement that I think we have with the plaintiffs on that. They think he was a neuroradiologist at that point in time. We don't think he was. I'm not going to spend a whole lot of time on the different considerations that go into that because that factual determination made by the trial court is reviewed for clear error. And I don't think there's any chance of there being clear error based on the competing factors that were presented. It's just something the trial court had to resolve. And I don't think it erred in determining that, he is 7 years removed from his last time practicing as a neuroradiologist. At that time, his practice was limited to diagnostic radiology. So that's the relevant standard of care. That's the relevant practice.
So Woodard defined specialty as a particular branch of medicine or surgery in which one can potentially become board certified. And a specialist is someone who can potentially become board certified. It also allowed for subspecialties. So under Woodard, why was it wrong for the Court of Appeals to hold Swofford as a specialist in neuroradiology?
So this gets back to defining what his actual practice was. And I agree, this is also a point that I think the courts are getting confused with because the concept of you can practice in an area without getting board certified. You can be a general surgeon who's not board certified. You can still be a general surgeon and also specialize in a subfield and not be board certified in that. But that doesn't mean that that physician's practice, right, that he is subspecializing in any particular field just because he happens to do something that subspecialty does.
So you're telling us we need to tighten up the language from Woodard?
Yeah, in particular, the quote that I read to you, where it speaks of the specialty engaged in by the defendant, I think you need to tighten it up in terms of explaining that the defendant's practice and what the defendant is engaged in terms of his overall practice is what is referred to there. So an example, right, an internist, right? I think I like to use internal medicine as an example because I think it's something everyone's familiar with, and the subspecialties are kind of more familiar to people. So internal medicine is a specialty cardiology is a subspecialty of internal medicine. Oncology is a subspecialty of internal medicine. So you can have an internist who might have, when I go in for an annual physical, my internist gives me an EKG. When he looks at those results, he's not practicing as a cardiologist. He's not reviewing that with the training and level of sophistication that a cardiologist would, right? But reviewing an EKG is definitely something that a cardiologist would do. So in terms of defining what he's practicing, the specialty engaged in at that moment, he's still an internist. His specialty is still internal medicine. He hasn't held himself out. He hasn't, practiced and done everything else a cardiologist would be, or would do at the same time. And that isn't to say that they can't. So I'll give you another example. It's from the Reeves case that unfortunately doesn't give us a lot of detail. But in Reeves, you had a physician who was board certified in family medicine and was practicing in the emergency department. And Reeves, the unfortunate part of it, that didn't give us the details in terms of what her actual practice was at the time. Because it's possible she still maintained a family medicine practice and then was doing emergency medicine shifts, once a week. In that case, she could be a specialist in both. She could be a specialist in family medicine. She could be a specialist in emergency medicine. Alternatively, she could have been like Dr. Swofford, decided on a career change. Started out in family medicine, got board certified in it, decided this isn't for me, and went and started working in the emergency department full-time. At that point, her practice is limited to emergency medicine. She's a specialist in emergency medicine. So in Reeves, they ended up concluding that, and it is related to her treatment in emergency medicine. I don't have a problem with the conclusion of Reeves. I don't see it as contrary. There's a lot of discussion sometimes about, is Reeves contrary to Jillick? Do those two conflict? I don't think that is, because we don't have a lot of details about the practice of Reeves. If she was practicing, taking shifts in emergency medicine, the malpractice occurred there, then sure, the universe of specialties, that foundational first step, would include emergency medicine. And so then she can be held to the standard of care of emergency medicine physician. In Jillick, it was a little different. I think the terminology in Jillick got confused because the physician was I believe another family practice physician who was practicing in urgent care. And a lot of the argument was whether or not that then is held to the standard of care of emergency medicine. Practicing in urgent care isn't a subspecialty. It isn't practicing in an emergency department. So in Jillick, the holding ended up being that the relevant specialty was family practice medicine. That was the only specialty that person practiced. Practicing at an urgent care isn't practicing emergency medicine. There is no urgent care subspecialty. And so the only specialty at issue, the only one that she had been trained in and was practicing was family practice. So I think all these cases are consistent. I think all the cases up to Horn and also Higgins versus Trail, which Horn adopted, are consistent in terms of they look at what the defendant's actual practices were. That's what they did in Woodward. One of the defendants had, I think, 3 subspecialties, and they considered among those 3 subspecialties was the malpractice based on. And I think you see that in all the cases. What our case and what Higgins tripped up over, and in particular Higgins, the error is particularly glaring, I think, because that doctor had never practiced neuroradiology, was never trained in neuroradiology. He was a diagnostic radiologist. He read a neuroimage, but so do all diagnostic radiologists. So if you're doing the steps that I lay out, define the universe of specialties based on the defendant's practice. His was limited to diagnostic radiology. In that situation, the next step is easy. If there's only one in the universe of specialties, that's the relevant standard. That's the standard he's going to be held to. That's the specialty that has to match for the experts. If there's more, right, if there's 2 or 3 specialties in that first step, then you look to, all right, what is the malpractice arising out of?
In your formulation there, when you say if we look to, are there more than 1, 2 or 3, are you including subspecialties in that?
Yes.
And is part of the problem, subspecialties isn't identified in the statute,
So,
right? That was a creation of this court in Woodard.
So, this is kind of what I will refer to as the nuclear argument. the way of dealing with this.
We like
and
nuclear
if you are
arguments, yeah.
inclined, and this question goes towards should we overrule Woodard? If you're considering that, I'm going to encourage you to grant leave to appeal. The order in this case asks us to address the statute as interpreted by Woodard.
As interpreted by Woodard.
So I would encourage leave grant. Overruling precedent is a pretty big deal. I would like the opportunity to brief it, but I will address the question.
Okay.
So first, to me, it's very significant that Woodard, every single justice on the court, agreed that the term specialty includes what these third-party independent organizations designate as subspecialties. And not to be flippant about it, but the running kind of joke in Woodard is they couldn't even agree on what the majority opinion was, but they all agreed on that point. And the second point on that, so I think that's pretty significant. The second point on that is I want you to think about this and do it with a mind towards the overall structure of the Revised Judicial Act, in particular the statute I mentioned earlier about the standard of care, MCL 600-2912A. That uses the same terminology. It refers to a specialist and practicing within that specialty. So that statute says the plaintiff has to establish that the defendant, if a specialist failed to provide a recognized standard of practice within that specialty. So you end up, if you don't include subspecialties within that, what it's saying is for a cardiologist, he's going to be held to the standard of care of an internist. For an oncologist, he's going to be held to the standard.
Those are two different issues, right? Like whether they're qualified as an expert under 2169 and what the standard of care is. And also, aren't we already sort of overly focused on sub 1 of 2169 as opposed to, don't sub 2 and sub 3 do some work in that? Where we're starting specialty, right? Like, and then 2 and 3 deal with those situations where maybe you've got an expert that's underqualified or overqualified, and 2 and 3 are where that sort of discussion comes into play.
So I don't think you can disregard 2912A and focus on 2169 because they're part of the same act. They came in with the same legislation. They're using the same terms. So I think you need to interpret them identically. They're the same. I don't think you can say specialty under this statute means internal, like the base specialty, but specialty under this other statute means specialty and subspecialties. I mean, I guess you can kind of do whatever you want, but
subspecialties. What if we just disregard the subspecialties?
Then you're disregarding it for 2912A too. Otherwise, you're going to have to explain why specialty under 2169 means only specialty, and then later explain why specialty under 2912A means specialty and subspecialty. And if you don't explain that specialty under 2912A means specialty and subspecialty, then you're going to have that weird circumstance I was referring to earlier, where you have a cardiologist, and the standard is you have to show that internal medicine is the standard. That's the specialty that you have to show that he fell below. It's a disconnect. And I think everyone kind of understands that cardiology is very separate from internal medicine. And you can play it out in all these different areas of practice. The other thing that I want to point out on this Woodard disregard subspecialties idea is if you look at the development of the legislation over time, and the brief submitted by the Michigan State Medical Society and American Medical Association goes into this in some detail in terms of how the legislation changed. It was practice in a specialty or in a related relevant area. That was the standard, and the legislature tightened it up in '93 after that. If you're going back to like, let's disregard subspecialties, then you're going back to that or in a related relevant area sort of construct. And if you're only matching specialties and you're saying, well, let's leave it to the trial courts to decide this under 702 or subsection 3, then you're going back to the body of case law that courts had before this legislation came in, where anyone who come in and say, yeah, I know the standard of care for X. I might be an internist, but I know the standard of care for cardiology, or vice versa. And I think the legislature, through its enactments, has shown that that is not the standard. That is not how it should operate. So I don't know how you adopt that interpretation of specialty without reverting back to that prior point that the legislature has repudiated. If there are any other questions, I'll reserve the remainder of my time.
Thank you.
Thank you.
Good morning. Ramona Howard appearing on behalf of the plaintiff appellee in this case. I'd like to start by saying that I believe, and I would urge the court not to grant leave in this case, because I believe the Court of Appeals properly applied Woodard to the facts of this case. The defendant's main argument below has always been that Dr. Swofford should not be treated as something he's not, and he's not a neuroradiologist. The problem with that is not the Woodard portion of the rule, but it's the Hamilton-Ackley portion of the rule. In Hamilton-Ackley, the court said, all right, we have to look at what the defendant practiced and what his specialty is. And they said the defendant was an internist. Now let's look to see what plaintiff's expert is. Plaintiff's expert was also a board-certified internist who happened to have an interest in infectious disease. He did a fellowship in infectious disease, didn't necessarily hold himself out as an infectious disease specialist, but by virtue of the fact that the community knew of that interest, he got referred patients a lot who had infectious disease issues. So when he gave his testimony, he said, well, yeah, the majority of my time is spent treating patients with infectious disease issues, but everything I do is under the rubric of internal medicine, because that is, in fact, what I am, an internal medicine specialist. And the Supreme Court rejected that argument. They said, no, we don't care that infectious disease is a wholly contained subspecialty of internal medicine. We don't care that you're not board certified. We don't care that you don't hold yourself out. You're fellowship trained in it, you practice in it, and because of the fact that majority of the patients you treat have infectious disease issues, you are not qualified to offer standard of care in this particular case because it's an internal medicine issue. Now, if we apply those same kind of concepts to the case that was before the court here, Dr. Swofford was board certified in diagnostic radiology. He did a fellowship in internal medicine. He had a certificate of added qualification in neuroradiology. He was chief of neuroradiology, practiced as a neuroradiologist for at least 10 years, during which time he had the added certification. And to this day, at least up to the time of these briefs being filed, his website for his office continues to hold himself out as a neuroradiologist. Now, the defendants want to say, hey, he only said when he got board certified and that lapsed. That, I think, doesn't matter because the certification is what he had. He had the education, the training, the experience, and the practice. So what did he read in this case? Dr. Swofford was reading a neuroimaging study.
All right, so let's go down the hypothetical path. What if Dr. Swofford had not previously specialized in neuroradiology or possessed prior training or certifications in neuroradiology, but all the other facts of the case remain the same? Would Dr. Swofford still have been practicing neuroradiology when he reviewed the CT scan of decedent's brain?
I think the answer to that is he's primarily practicing, this goes into the issue of the overlap. So yes, I think what he was at the time he read it, if he never was certified, never trained, he would have been a diagnostic radiologist reading a neuroimaging study.
So isn't there a problem with holding physicians to a higher standard of care simply because some of the tasks that they do perform, others perform in a particular specialty? Are all physicians specialists under Woodard simply because they have become board certified in a particular branch of medicine?
I'm sorry, I don't think I followed that question.
All right, I guess I'm having a hard time, and I think there's a problem that we're going to hold physicians to a higher standard of care simply because some of the tasks they perform in their specialty are also performed by other specialties or subspecialties.
I agree with that, but that is not this case, because I believe in this case, Dr. Swofford is not your average general diagnostic radiologist who's reading a neuroimaging study. He has a fellowship, he has 10 years of experience, he held himself out to being a neuroradiologist. He does 25% of his practice in neuroradiology. This is not a one-off situation where you got a guy with no training, no experience, no extra in neuroradiology. He is a neuroradiologist.
So are you saying that in a case that the better case to address the problem is a case like Justice Zara's hypothetical, where the defendant doesn't have what Dr. Swofford had as far as neuroradiology?
I believe that would be true. I absolutely believe it's true. Now, in this particular case, if you believe if you adopt or accept the defendant's assertion that Dr. Swofford is a diagnostic radiologist, so as a result, plaintiff's expert, who is also a diagnostic radiologist who reads neuroimaging studies, is board certified in neuroradiology, and spends the majority of his time reading neuroradiologic images, he's not going to qualify to offer standard of care testimony. And that's why, quite frankly, when I was getting ready for this argument, I had a bit of, I grappled with how to present this because, quite frankly, as I said, I believe the Court of Appeals got it right. But if the court takes the turn and says that diagnostic radiology is what we should be matching here, then we have the whole Woodard problem as to whether or not Woodard should be revisited. And quite frankly, Woodard should be revisited, whether it's in this case or whether it's another case. Woodard absolutely needs some tweaking. We practitioners, and I think the lower court judges, all need some help with respect to how to treat Woodard and what to do. And with respect to Woodard and whether or not it needs tweaking, the three areas that I think it made the largest errors that have led to all of these conflicts and problems are three points. One, they conflated specialties and subspecialties. I know I cited in my brief, and I think the negligence section cited in their brief, statutory language that shows that the legislature knew the difference between specialties and subspecialties. They absolutely know the difference. The other area that I think they made a problem with in saying that the holding in Woodard conflicts with its own definition of specialty. It says a specialty is an area of medicine where one could become board certified, and a specialist is a person who could become board certified in a specialty. Only specialties can get board certification. Subspecialties get certificates of added qualification. They are not the same thing. And if you don't believe me, which you don't have to, you can look at the deposition of Dr. Berger in this case, who was plaintiff's expert. The defendant went to great lengths to point out that Dr. Berger's affidavit of merit was inaccurate because it said he was board certified in neuroradiology when all he has is a certificate of added qualification. So those are two errors. But I think the most glaring error in Woodard is the error that is causing the most problem. It is this idea of overlap that we've already discussed. The core of Woodard is that a subspecialty is separate and distinct from its overriding specialty. To me, that is completely illogical. I mean, let's forget about legal issues, but total logic, it fails. I remember when I was in 5th grade, and this may be dating myself, but we drew Venn diagrams. So you draw the big circle, and you have all the world of doctors, and then you draw a circle within it. Some of them are internists. And then within the internists, you draw little circles for all the various subspecialties. So what we know from that is every person who is an infectious disease specialist, a cardiologist, a geriatric specialist, they are all their own specialty, but they are all wholly contained in internal medicine. They're all internists. So to suggest that, as in this case, a neuroradiologist who reads all films all the time, because he's primarily a diagnostic radiologist, that a neuroradiologist is going to be disqualified from reading a neuroimaging study, from offering expert testimony against a physician who read a neuroimaging study simply because he spends more time in the little wholly contained circle and doesn't practice in the big circle is illogical. They're all in the big circle. They're all in the circle of diagnostic radiology. The other problem...
Counsel, I think you raise really important points, and I know we'll grapple with some of that overlap in another case that's coming up on this call. But I'm wondering, how do we mesh, in this instance, this case is unique, obviously, because we have this lapsed specialty certification. And I know in your opinion that doesn't matter. I understand we have this website where, Dr. Swofford held himself out. I understand that. But I do find it compelling. Certifications obviously require a lot of work. There could be new technology. There's lots of reasons people get certifications and lots of hours and experience required. Does that matter at all in this case?
I don't believe so, because you don't need a certificate of added qualification and you don't need a board certification to hold yourself out as a specialist. Woodard made that clear, and then the language of the statute makes it clear as well when it delineates what you need if a person's a specialist and if a person's a board certified specialist. So you can hold yourself out as a specialist without doing all of these other things. So you're going to be held to the same standard.
Okay,
so I don't think that makes a bit of difference. I think this whole impracticality of overlap is the reason you get cases like Turkish. Turkish was an unpublished Court of Appeals decision wherein the defendant was an orthopedic surgeon. And his expert who testified on his behalf as to the standard of care was also an orthopedic surgeon who was fellowship trained in sports medicine and testified at his deposition that he spent the majority of his professional time in the area of sports medicine doing sports medicine procedure. And then on redirect he said, yeah, but everything's under the rubric of orthopedic surgery, so there's all this overlap, and and most doctors who are orthopedic surgeons treat sports medicine issues, and all of that may be true, but all of it is completely contrary to what Woodard said, that we don't look at overlap. And the Court of Appeal, the trial court and the Court of Appeals all said, yeah, he can testify, which baffled me. And I asked them to publish the opinion, and they said no. The defendants opposed. The Court of Appeals denied the request, and we ended up with a case that completely conflicts with Woodard. And if you look at almost every case where we're having this conflict, it's almost always in a case with a specialty and in a subspecialty, and it's because this simply does not make sense.
Counsel, let me ask you just
Sure.
one question, since you brought up your Venn diagram.
Yeah.
And I agree with you, this is a difficult area for
Yeah.
practitioners and for trial judges. And if we could find a way to make it easier, I'm sure we would. I'm not sure that that's available.
Right.
And one reason might be, and I have a question for you in your Venn diagram, aren't there multidisciplinary subspecialties that can involve multiple board certifications? In other words, I'm not sure I agree with your Venn diagram. There's some that aren't in the circle. There's some that are overlap two circles, I think.
Well, that may well be, and in that case, we have to determine what specialty. If for example, if you're internal medicine and something else, and not family practice. I can't think of another specialty. But if there's an overlap, then we have to figure out which one.
Looking at like allergy and immunology.
Right.
Or, you have it's internal medicine, but then you can get board certified in rheumatology, other areas
Right.
too. And
Right.
so your subspecialty involves multiple board certifications. I'm not trying to be an apologist for Woodard, but that may be why Woodard decided to say, you know what, we're not going to distinguish in this hierarchy because everything's not equal. There's different subspecialties that are going to involve, that can cross over. that can be so unique as to not, not involve the broad practice of the specialty, but to be so, discrete and unique that that's how we'll just treat it that way.
Well, I think in circumstances where there's multiple specialties or the overlap and these other things, you can consider, like for example, what the council was saying, with cardiology and internal medicine are very different. Well, that may be true, but that can be a 702 issue, and ultimately an issue of whether or not they should be allowed to testify based on other factors. Is it reasonable? Do they really have the most insight into what a cardiologist would do? Maybe a cardiologist would be better. All we're talking about here is if we can meet the standard of 2169. There's the 702 and these other issues that it filters through. And the defendant's suggestion that somehow if we require only matching of specialties, we're going back to the pre-statutory wild, wild west, if you will, of experts. It's just not accurate, because if you look at what was happening before, OBGYNs were testifying against general surgeons in areas that were not even in the same specialty. This interpretation of Woodard under the statute would allow us to at least have everybody within the same specialty, and then you look at 702 and you make your other determinations, which is what properly should be done.
So if, getting to your point and what Justice Viviano was talking about, so we have diagnostic radiology. What if the defendant, looked at this brain image, but really it was a rare part of his practice, but diagnostic radiology, obviously, practicing diagnostic radiology. And the expert you were offering is also a diagnostic radiologist, but mostly just focuses on, I don't know, intestinal issues or something. So rarely looks at neuroimages. They're both diagnostic radiology. Right. So are you saying then that's when we would look to 702 and determine if that expert is qualified?
I think under that circumstance, it might be the weight for the jury to look at, because under 702, he would be trained in diagnostic radiology, familiar with reading them, even though not as familiar as the defendant. I think in that case, that might be a weight issue as opposed to an admissibility issue. But if we want to look to see for a judge to determine whether or not an expert should be qualified to testify, and whether or not an expert can offer insight to the jury to help them make the determination, that's the 2169 and the 702. And then we go to, can we attack his ideas and thoughts, the experts, based on any holes he might have in his training or gaps. I think those are the types of things that would be more appropriately addressed as a weight issue to be assessed by a jury as opposed to weighed by the judge.
Thank you.
Thank you. Unless there's any other questions.
Nope, thank you.
Thank you so much.
I know it's argument, it doesn't sound like it necessarily, but we actually agree on a lot, I think. In terms of Justice Kavanaugh, your question about the better case, the one that Justice Zara was describing, that's Higgins. That's the diagnostic radiologist who had no training. And this is the case to address that too, because the published opinion in this case adopted Higgins and endorsed that result.
Do you think Woodard is correct?
I do.
Okay.
I think it's the specialty, the subspecialty, I still think that's workable. And I think this is a good case for this court to lend clarity on the point that I pointed out at the beginning of the specialty engaged in, and clarifying the first step in the analysis is determine the universe of specialties. And that's what happened here. You have a record where the plaintiff went online, saw that this physician had prior board certification, reasonably concluded that he was a neuroradiologist. We're not challenging the affidavit of merit. It is reasonable for them to do that. Then you take deposition testimony and find out what his actual practice is. And at that point, the trial court has to make that factual determination in terms of setting the standard of care. And the trial court did that. It's an issue that's reviewed for clear error. But I think this court can set out in an opinion, that's the first step. Determine the relevant universe of specialties. If there's only one, that's it. If there's not, then you need to look at the various specialties and decide which specialty the allegation arises out of. And honestly, I think we agree too, and I think she acknowledged, if diagnostic radiology is the only specialty, then that's the specialty. And if if the trial court clearly erred in determining that he was only a diagnostic radiologist, if he determined there are two specialties, that he was also a neuroradiologist at the time, then I would agree. He's held to the standard of care for a neuroradiologist. I just don't think the trial court clearly erred in making a determination, and I think the Court of Appeals erred in skipping over that first step of determining the universe of specialties and giving the clear error review for that first step.
Thank you. Thank you
Thank you.
both. The case will be submitted.